Today I'm going to talk about the enforcement of non-compete covenants in Tennessee. I'm going to cover general principles that apply. I'm not going to address the specific statute that deals with physicians, but these are going to be principles that apply to any non-compete that a Tennessee court is looking at when applying Tennessee law. First of all, the Tennessee cases say that while non-competes are not favored because they're in restraint of trade, they will be enforced if they're reasonable. To determine if they're reasonable, the courts look at four factors: the consideration provided that supports the agreement, the threat and danger to the employer without the non-compete, the economic hardship to the employee imposed by the non-compete, and whether the non-compete is contrary to the public's interest. As far as consideration, that typically is the employer gives the employee a job. Consideration is the benefit that the employer provides that supports the contract. So either having the agreement entered into at the beginning of employment or just continuing the at-will employment of an employee for some period of time after they sign it is typically sufficient consideration. The next 3 points all really are subsumed under the concept of the employer's protectable interest. That is the threatened injury to the employer, the economic hardship to the employee, and the public interest. So, and the employer's business interest really focuses on 3 key factors: whether the employee has had access to trade or business secrets while working for the employer, whether the employee is really viewed by the customers as the face of the employer, the face of the company, and whether the employee received some kind of specialized training. So confidential information really is very similar to the concept of trade secrets in Tennessee law. It's going to need to be confidential, economically valuable, and subject to use by competitors. And the employer's interest there is the employee won't use that type of information against the former employer. As to the face of the company issue, that this involves where the customers interact with the had interacted with the ex-employee during his employment sufficiently so that they really viewed him as the company, or as the goodwill of the company really rested on the ex-employee. So the employer's interest there is not to have the ex-employee use the goodwill against it and get that relationship rebuilt by other employees. And then specialized training is an issue that comes up. Remember, the training that just makes someone better, or the improvement of their skills, or their general improvement of their knowledge of their job, that is not going to be specialized training and protectable by non-compete. Specialized training is some type of unique knowledge and skill the employee receives through training at the employer, and this has to be something that's unique to the employer that's not available for other employees. Now, one or more of those 3 things can form a protectable interest, each one individually if they're strong enough, or all 3 together, or some combination. Now, then this is an important point, number 4. Under Tennessee law, a covenant not to compete is enforceable to the extent necessary to protect that legitimate interest the employer has. That's going to be the training, the confidential information, or the goodwill, typically the face of the company type of argument. So that defines or determines kind of to what degree a non-compete will be enforced. So what are we usually talking about in terms of the scope of a covenant? Well, usually, point number 5, usually that involves a limitation on customers or a limitation on type of work in a certain geography. Right? And so the employer is going to have to show that whatever these restrictions are it's seeking to enforce in court, really, whether customers or geography are needed to protect one or more of those legitimate interests. So if it goes beyond what the employee knew or where the employee worked, that's going to make it difficult to enforce. Point number 6, how long can you enforce a non-compete? Well, that again depends on the employer's showing of its legitimate business interests and how long is needed before the competition is no longer unfair. For instance, in the face of the employer type argument where the employee is really the one the customers know, the employer is entitled to have someone new hired and then give them a reasonable period of time to rebuild that relationship before the ex-employee can interfere with it. So in terms of length, 1 year, 2 years, those are often enforced in Tennessee. It may be even longer under some of the case law, but again, it all depends on the employer's showing of that legitimate protectable interest and how long is needed to really protect that. Or on the flip side, when it's really just after, at some point, ordinary competition. So point number 7, what if the covenant's too broad? Will the court just strike it down or rewrite it? Well, unless the covenant was entered into in bad faith, the court will often rewrite it. So that means the restrictions may be reduced, but they'll still be enforced as written rewritten. And what that also means is, again, it's going to be tied to the protectable interest. So the court is going to look at what's really necessary to protect the employer's legitimate interests, and then the court will enforce the covenant not to compete to the extent of those protectable interests. Number 8, what about extending the covenant for noncompliance? So say an employer had a 1-year covenant and the employee cheated for 6 months before he got caught. Then the employer sued him and got an injunction 6 months into the 1 year. Well, what this argument is the employer should get a full year of a non-compete, but it wouldn't run from the end of employment. It would run from when the injunction was entered. And there is case law that does that. It just depends on the facts the employer can prove to the court. But there is case law that supports extending the covenant from the period when non-compliance ceases. So I hope this helps you understand the enforcement of covenants not to compete in Tennessee and gives you some insight into how the courts will look at them. Thank you.